My name is Clayton Chamberlain, and I'm here to talk about copyright law for you guys. And I'm a mentor for the Forge, and I've helped some Forge companies through the various legal business issues. And it's been very interesting to see how companies come across their first sort of major legal issues and sort of the path that gets them to that point. And it sort of struck me in that time period that I spend 12 hours a day looking at every possible angle relative to these legal issues. But if you're a business that's just starting and you're a technical expert in whatever field you're in, you're blowing and going and everything's looking great, and then all of a sudden you're have a complete business model, you're ready to accept investment, and then at that point in time, someone comes along and says, well, did you consider this? And that can sort of unravel all of that hard work. And my goal through this is to just sort of outline where the traps are and allow you to, when that time comes in your business, or it may never come, but to be able to recognize these problems as they're arising and sort of decide at what time it's worth your time and effort to go try to either protect against it or stop it. So with that said, the topic I wanted to talk to you about today is the DMCA, and really there's a lot of interesting case law that comes out of this, and I think the reason it's relevant to startup businesses is when you're advertising online, they say that content is king, and you're really driving forward to try to obtain visibility by publishing and posting content. And one of the mechanisms that is very useful and is YouTube. And YouTube, posting videos on YouTube raises a whole lot of copyright concerns, because essentially with copyright, it's anytime you put it into a fixed medium of expression, someone's ideas, and publish it, that person owns that fixed medium of expression forever, or 70 years, the lifetime of the author plus 70 years. And when you're borrowing it or using it as part of your material, advertising material, you need to be aware of how to protect yourself from copyright infringement lawsuits. And you don't really run into them all the time because they're expensive lawsuits to bring, and they have to be valuable fixed mediums of expression, but they're out there pretty much everywhere you look. And I wanted to show you relative to YouTube, because I think that's a platform that a lot of people really utilize. This is a recent case. They call it the dancing baby case, and after I show you what copyright infringement looks like, I'll explain how we got here and how ridiculous facts make good law. So. Well, there you have. That's the face of copyright infringement right there, and that's what it looks like. That's who Universal Music decided they were going to chase down. And the question I have for you, and I'll sort of answer it if you guys don't want to take a crack at it, but do you guys have any sense on why that might be copyright infringement? That video there, publishing it, it was a mother. Her name's Stephanie Lentz. And she lives in Northern California. In 2007, her kids were just going crazy in the kitchen, pushing their strollers around in circles, and she thought it was hilarious, and decided that she was going to record it on her phone, and then she decided to share it with her friends and family on YouTube. And then before she knew it, the video itself had been taken down off of YouTube. And really, I don't know if you could hear it in the background, and that's kind of a very important issue here, is Prince Let's Go Crazy was playing in the background of that video. And that's why the kids were so excited. They were listening to the music and running around. Well, Prince is sort of notorious for aggressive copyright infringement. He was one of the persons that said, at all costs, a small infringement, a lot of small infringements erode your musical rights. So Universal Music files with YouTube a takedown notice. YouTube responds by taking it down, and at this point, most regular people, and me included, would say, well, this isn't worth the fight. You know, it's just a video, I'll just let it go. But Stephanie did not let it go. She filed a counter notice, which most people never do, to YouTube. And YouTube, giving them credit, decided that they were going to put the video back up. But Mrs. Lentz wasn't done there. She then filed a lawsuit in the Northern District of California saying that Universal Music Records went too far. And the interesting thing here is there's a lot of abuse by record labels and other publishers because they know that of all of the infringement notices they send out, very few of them are ever going to be challenged, and they could deal with those on an individual basis. But women like Mrs. Lentz are the people that pay the price for it. So the basic copyright ideas, it's a property right. Everybody has an exclusive right to copy, distribute, or publicly display their fixed medium form of expression. And really, this is all about incentivizing people to be creative. So you wouldn't do something if it could immediately be stolen, so they want to do that and give you sort of monopoly on that fixed medium of expression. And this is the major concept that the first thing I want to get you guys to understand is what fair use means. And fair use, as they determined in the Lentz case, is not copyright infringement at all. It's not like a defense, you infringed, but it's fair use. Fair use just isn't copyright infringement. And these are the concepts for fair use. And as you can see, I'll go through each of them, but the first one is where a lot of businesses get in trouble, where Mrs. Lentz didn't have that problem because she wasn't selling something in connection with that publication. So you can, it's probably the heaviest weight factor here, but essentially whether or not you're using it for a commercial use is important. It's the strongest factor, which all of us, if we're publishing content in connection with our businesses, are going to be somewhat indirectly using it for a commercial use. So your YouTube videos, for example, this talk here, playing that video, or playing music, or showing you a movie, it stretches this concept of fair use as to what purpose is it serving in connection with this event. This is an educational event, so it falls under non-commercial purposes, but as you can see, there's a gray line with all of this. The second thing is the nature of the copyrighted work. That goes to, is it an image? Is it someone's journal entry, diaries, or is it a published book? The nature of the work determines how much copyright protection that it gets. And then the amount and substantiality of it. In that video that you saw in the Lentz case, there was a small portion of the song, it was inaudible, it wasn't the focus of that video. And because it wasn't the focus of the video, the courts determined that it was fair use, and they shouldn't have sent the notice in the first place. And there's actually, you can get fined for sending a fraudulent notice. And then the effect, this is really, ties to that first element of fair use, which says the courts to look at, and in connection with your businesses, are you deteriorating the value of whatever you're using? So the examples of these streaming music services, the initial ones, which we'll go into the Napster case a little bit later, the big problem with that is they were essentially replacing what would be a sale of music, which would benefit the copyright holder, and they're giving a free copy of that. And the effect on the market, they're still trying to figure it out, how music can get back to its pre-streaming days of revenue generation. And that's what this last thing here says, is essentially that's really the question you have to ask. When you're using something, are you using all of it, and are you using it in a way that deteriorates the value of what you're using? So music, if you're using it to replace the mechanism. And that's why in 1998 they came up with the Digital Millennium Copyright Act, which is really broken into two parts. And I won't go into much detail on the first part other than to tell you just the basic features of it. But the second part of it, which provides this notice takedown procedure, is something that's very useful to protect your use of any copyright materials, because it shifts the burden. Otherwise you'd be liable for copyright. This says that if you fit in one of these categories, it shifts the burden to the copyright holder to let you know and give you an opportunity to resolve it, which is, it really did change the whole framework of how this works. And the first part is anti-circumvention, and I know I've received some questions about what this clause means, and really it's about creating either technology that allows you to take away the protection mechanisms within whatever you're using. So if it's a book, if you're a digital book and you're scraping off the code that they need to identify it so you can read it on different devices, or software, and you're deleting the text file that says this was initially created by so-and-so person and I'm using it in connection with my software, you need to be very careful that you're not changing the copyright management information by accident, because you're better off leaving it all in there and then arguing about how you're making a fair use of that, rather than going all the way back and getting caught under this anti-circumvention clause. But the real focus of what would be useful to, I think, a lot of businesses, I in particular have a software business related to playing streaming music via the Chrome extension on the Chrome browser. The problem that you run into with that is, when do you become a performer of streaming music, and when are you just we think of it as sort of a boombox, a way to play streaming music in the browser. And that barrier, the protection that we have against a ton of copyright infringement cases, although they would be wrongfully filed, but having to defend against those, is having a copyright policy under the Digital Millennium Copyright Act Safe Harbor provision. And basically, you could think of YouTube as a great example of this, but people publish infringing materials all the time on YouTube. It happens nonstop, all day, every day. What YouTube utilizes is the 512 Safe Harbor provision, and they have a takedown notice procedure that allows them to, because they are really in the hosting function there of those 4 different functions, what people will do is they will go to the copyright policy, review, there's 6 items that you have to prepare to send to YouTube in order to get a takedown. And once they take down that material, they'll send you a notice. They'll send the person whose material they took down a notice saying you have an opportunity to counter notice, like Ms. Lentz did. And if there's a counter notice, they'll assess the claim and either put it up or take it down. But that completely protects YouTube from copyright infringement for the stuff their users publish. So this could be relevant to you if you have on your blogs comment sections. You're responsible for making sure that your website doesn't publish infringing material. And this is something that gets lost in the terms and conditions in people's websites, is they don't provide this copyright notice mechanism to protect them from that sort of thing. Now, there are things that will totally disqualify you from these safe harbor protections, which we'll talk about the Napster case and how they failed to meet these disqualifiers. That is, you have actual knowledge that people are using your framework to publish infringing material. Now, if you have control over it and you don't exercise that control to remove material, and if you get direct financial benefit. Now, that last element of disqualification is a very tricky one, because direct financial benefit doesn't mean that you're selling the copyrighted material. It means that you're using that copyrighted material as a substantial way to either gain users. You know, the quintessential example is to gain eyeballs, to sell ads. That's the one that gets a lot of people in trouble. People would say that's not direct financial benefit. However, that's not really the case. And then once you have that procedure set up, you have to designate a copyright agent, and then it's like a registered agent for your business where you send the Secretary of State, this is who my registered agent is. You send the Copyright Office for $105 a notice saying this is my designated copyright agent. There's businesses that's all they do is service these agents. And then you publish your copyright policy on your website, and then you have to make sure you comply with the procedure, because if they really do pick at it and you just have it up there as sort of a sham copyright policy, then you really have to, you're going to lose that argument. Now, these are some general rules related to copyright policy, and I have a handout for you guys related to this that's sort of really general. I guess I'll start down here and pass it that way. But essentially, where you really gain, and this is a struggle that if you have a service where your users are actually publishing content on your website, is at what point in time do you terminate their access, either in a comment section of a blog, or if they're publishing videos, or you could have a situation where your clients share videos to other clients on your website, and those videos contain infringing copyright material. You really want to make sure that there is a clear-cut policy that you have that provides for termination for their access to whatever their service is that they're using for you. So if they're commenting on your blog and they're posting pictures that are copyrighted or videos that are copyrighted, you need to be able to terminate them. Some people, early on in our music software business, we didn't have the means to track users, because in our mind, our philosophy was, this is really annoying. Why would we want to email, confirm, track users, and have a way to individually identify them? We just won't deal with that at all. And we'll have a random ID, we won't be able to find them, and that'll be all right. Well, that's, under the law's willful blindness, we eventually realized that we needed to come up with a plan or process to find a user, notify them, provide a counter notice procedure for that user, and then terminate their account. Have the ability to and actually terminate their account if they were infringing. And a way you could have it in a music service is if users were using our software to connect with pirated music services. So we're very careful that the services we use are only services that the users have rights to use that actual service, whether it be Google Play Music or Amazon Music, and that's really where the right is obtained to play that music. Now, in building your process, each situation is different. If your service or your website just has comments, and you maybe will get one of these notices in like once every 2 years or something, then you really don't need a complex form. You just really need to provide them with a way to mail you a notice that provides you with the information so you can address it. Because the risk of not having a copyright policy set up is that you don't get the safe harbor at all, and it's just flat out copyright infringement. And the theory of that is under what's called contributory or vicarious liability, which in legalese, the contributory is sort of like the employer-employee situation, where you're the master and you're sort of considered to step in the shoes. And then the vicarious is that. The contributory is you provide them with the means to cause the actual harm, which the situation like YouTube, that's what you would have there. And so what I recommend in relation to the copyright policy is not that you run out, register an agent, and write a copyright policy, but just in your websites or however you're looking at and expressing your business to the public, that you consider what materials that might be published on there that would infringe on copyright, and determine as a business judgment decision whether you need to add a copyright policy and register an agent. And I think most businesses that aren't using high volumes of user posting and hosting, you're probably not ever going to run into this issue, but the cost of actually getting sued for copyright infringement vicariously, and you'll think to yourself, we'll go through the Napster example really quick. You'd think to yourself, I did nothing wrong here. There's absolutely nothing that I did that was infringing. It was this user who I didn't know, who I didn't invite to my system, who used my framework, sort of trespassed to post infringing material. But you're providing them with the means to be able to do so. And that really sort of sums up the DMCA part that I think would be relevant to people having advertising material. And if anybody's got any questions on that, or just in general about copyright and copyright law, I want to go through an example with you after the questions to sort of take you step by step and sort of give you the way to think about this if you ever run into a problem like this. But I'd like to see if anybody has any questions. Go ahead.
Yeah, that's happened to me several times. In fact, because I do create original content for music.
Yes.
Quite often, and that has even gotten copyright infringement notification.
Right.
Original content that I've created.
Right.
So
and here's
a way to fight it.
Yeah, there is a way to fight it.
Okay.
But this is the way to fight it. But here's what's happening. And this lens case, that's really what's behind this lens case problem. So YouTube and a lot of other services have software that crawls the web and checks for registered music audio files and sees if it matches a copyrighted music program. And when it comes close, it triggers and says, well, this is infringement, send off a note, figure out where that IP address is, they find who owns it, and they send a notice. And what happened in the lens case, that's exactly what Universal Music does. They have an automated system, and what that automated system wasn't doing was determine whether it's fair use. And it's really a very subjective analysis, so it's hard to have a computer analyze whether it's fair use because it's only registering different audio mechanical stuff. It's not registering whether it's used for commercial use, whether you're having a substantial effect. You really can't do that through a computer. So it adds a human to that process, which is expensive for a record company that's patrolling the world. So what's happening, I think, in your situation is that these web crawlers are hitting this original content music. It's coming close to something that's in their records, and they're sending you a notice. Now, what your response to that is, they're exercising what they think to be a copyright infringement notice under these safe harbor provisions. You need to send them back a response saying that it's not copyright infringement and that you really don't have to go into detail as to why. You just, if it's your own content, make a record saying why it's fair use and put it in a file somewhere and send back a notice or a sort of counter notice saying that this is original content and it's not copyright. You have a right to file a counter notice with YouTube, and YouTube is that's why they're the most popular service for music and video and everything. They do stand their ground in protecting their users' interests, which they did for Miss Lentz. They put her video back up. But you go through that analysis, that fair use analysis, and that's really where you either win or lose on these sorts of complaints and things of that sort, because their automated systems aren't checking for fair use. They have to go through a human being to really analyze it. And when you send back that counter notice, if it's not for a commercial purpose, and it could even be for a commercial purpose, but then you have to have the other factors have to be really strong, like you're using a very small part, and if it's totally original, then you absolutely need to enforce your rights, because with intellectual property just in general, you start losing, your rights start eroding if you don't enforce your right over time. Trademarks is the strongest example of that. Copyright inherently is sort of the one of the more fundamentally strong areas to protect their holders, but you should file your counter notice and protect your stuff, especially if it's original, absolutely. And if you're borrowing pieces of other copyrighted material stuff, then go through that fair use analysis with your 4 points and determine, make a little record for yourself. You don't just put it in your file. So if anybody ever asks, because you won't remember it, and by the time they file the lawsuit, and they probably won't, but if they do, you'll have that for you. Remember why you thought that particular video, and YouTube will put it back up if they think your counter notices make sense. So, any other?
What was actual holding in the Lentz case?
The Lentz case holding was that the Universal Music Records did not assess for fair use. So in sending their first notice to her, there wasn't a good faith basis for them determining that it was copyright infringement, because they didn't do 50% of the analysis. They did the first 50%, and the other 50%, which is really the only reason copyright law in balance works well, is because you have this fair use aspect of it. It allows, part of the copyright law rationale is you incentivize people to pursue their creative ideas, and they can protect them and make money off them. But the other side of it is that eventually it gets released to the public, and we all get the benefit from it. And we all get to use parts of it in the growth of human capital around the world. Without the fair use part of that, you don't really get the fundamental purpose of copyright law. So, but the holding was that that she had won because the initial notice wasn't made in good faith. And then the result was that now they have to go through a fair use analysis before they send their notice. Some of them don't, but a company as large as Universal that sends, they have entire notice departments, have to incorporate this, otherwise they're going to be stuck with a lot of Mrs. Lentz's. So.
How does, I noticed that you had news up there for fair use.
Yeah.
I won't watch Sports Center. I look at Sports Center because they have the highlights, right?
Right.
So, and that's why I watch the commercials.
Right.
So how is that not commercial?
For Sports Center?
Yeah. It's.
Well, they're compiling, they're creating a compilation. So they're first creating something new, other than just the initial cast, and then secondarily they're licensing all the rights to the stuff and paying.
NFL, NBA, and
Right, and ESPN's got a nice luxury; they own most everything.
Right.
So, including our opinions on it all. Yeah. So, but.
Hey Clay, it might be interesting who to find out who might be producing their own content versus the people that have websites or whatever where they could be a conduit and fall within the safe harbor provision.
Yeah, absolutely.
So just as a poll, who here produces their own video or text or whatever content? Okay, I know Roger does. And then who has a website where they allow either others to post content on their website or allows commenting on their website by
Right.
others?
And the conduit's a good way to think of it.
Platform,
yeah.
conduit.
Now, does anybody?
That's what YouTube is, right? YouTube
Yeah.
is the platform and the conduit. So does anybody have a website that does that? They allow comments or other people to publish on their site? Nobody. Okay.
Not comments, but it could just be text.
Right.
They can't upload their own content, they can just put comments on there, okay?
Right. Okay, well, any other questions? Otherwise, I'll go through an example, if everybody's asked their questions, you might have another, go ahead.
Quick question, do you know what Tor is? Router?
Yeah, yes.
Do Tor exit nodes fall under safe harbor provisions? If you operate a Tor exit node, or should you monitor traffic and try to, you can't really shut it off, but you
Right.
need to shut down your exit. It's called the onion router.
Tor essentially, correct me if I'm wrong, but you send your communication through the internet all have attached IP addresses which is where you're located and how they identify you. And the Tor system essentially redirects that and creates a new unidentifiable location where that message has come from, so it sort of wipes the path. Is that pretty much correct?
Yeah.
And so the issue with Tor in particular is very unique because you can never identify who the publisher is. So it's if you could find that person, you could subpoena Tor and ask them who that is, but I'm pretty sure Tor has a mechanism for completely scrambling.
Tor has no idea either.
Yeah, they don't have any idea, right. So Tor, that's really where you can't enforce anything against people passing their information through Tor, and that the same goes for all the different note-taking and things that happen within the system.
So if there's no reasonable enforcement mechanism for you to use, does that just de facto mean you're not responsible for what passes through?
No, it means that the businesses that have the copyrights or the copyright holders don't want to spend the money to go find out who it is.
Awesome.
Because it's extremely expensive, and unless if there's a system that is totally undermining that market effect aspect of it, undermining all the money making potential of a particular copyright product, then that might be worth going after them. But people just, copyright infringement just happens nonstop all day, every day, and they got to pick their battles, and they go for the battles that affect the bank accounts the most. So, well, last thing here, Napster's sort of a very interesting story because they really began the public awareness of where this was going. This is 2001, so we're looking at 1999 was right after the Digital Millennium Copyright Act. And in fact, they thought, if you watch, there's a documentary downloaded at Parker, and a lot of the attorneys thought at the time that Napster would fit safe harbor rules and they'd be good to go, and that wasn't the case. And really, if you look at, those are sort of your 4 things to think about when you're dealing with a copyright problem. What rights are infringed? Is anyone going to take a crack at what rights are infringed by well, actually, first of all, I'll tell you a little bit about, if you don't know how Napster works, I'll give you a quick, this is how Napster works. User 1 and user 2, this one these are just records here, had music on their local computer, so on their hard drives. And you would download from Napster a software program, a file share software program, Music Share, and you would, through that software, put all of your MP3 files in that software, and that would communicate, the software would communicate with Napster on both of these, and it would create a directory, an index of all over the world, all the software MP3 files sitting on people's computers. And the unique thing about MP3s, we think about them as being all music is digital music MP3, but back then, at the time, it was only becoming a popular format because people were now transferring and sharing them, and the quality was great. Before then, it was impossible to get a good music file transferred digitally, but this sort of really changed the whole nature of that. And what ends up happening is user 2 asks Napster who's got a Prince song. They say user 1 has one, and then once that connection is made, user 1 and user 2 directly connect. Napster's gone. User 2 copies user 1, and that's the end of it. It never gets stored on the server. They're not going to the main server. So they thought through this process that they weren't violating copyright law because user 1 and user 2 were violating copyright law, and it never touched the Napster system. But, so rights infringed are your right to distribute and your right to reproduce. So that copy file transfer is a reproduction and it's a distribution. But Napster's really not involved in that system, but for providing the means and utility to connect copyright infringers. And that's where your fair use problem, where you run into a problem with fair use. What's the purpose of Napster? To connect copyright infringers to transfer copyright music files. There's other alternative uses, but I mean, it's laughable to think that Napster was for any other purpose. The second aspect of it is what is the nature of the copyrighted work, music. There's an entire industry that's all about recording and protecting and copyright. The nature of the music file is one of the highest levels of protection in copyright. And then substantially in the amount, the entire, you're creating an exact copy. There's no only a piece of it or a small file, and you'll notice it's actually created in particular rules, but sound samples less than 30 seconds. There's a carve out for that. So that's why you hear 30-second sound samples passed around all the time. If you go on these music stores, you can listen to just about any song for 30 seconds. But that's a sampling thing that's sort of a way to advertise, really, not a way to, steal music. And then contributory and vicarious, they really did here create a scheme, although they claim that wasn't their entire purpose, for allowing people to commit massive copyright infringement. And the market effect for this was we're watching it still today. They haven't really figured it out, how to get back to controlling music distribution. They're doing a pretty good job. I think they're shifting the market entirely, but the market effect was unlike anything else we've ever seen in how it completely changed how businesses make money off the sale of copyright materials. So that's how you go through the thought process of whether or not you're going to run into copyright trouble by posting and publishing copyright materials. And the DMCA provides you with the safe harbor protection that you really, if you're in this business or in this area, it's something you really need to utilize to protect yourself, because I think the copyright, each infringement is like $25,000, which is, you have to get liable for it, but the amount of damages is enormous. You never actually get a trial and get those damages. They always settle for something less than that, but it's serious risk, and it's something that you don't have to have the intent to steal someone's materials to find yourself in deep water. But that's about it. That's sort of my showing you guys what this world looks like and how to recognize when you might be running into a problem with posting, and YouTube is a good example of it. And I suggest you work through sending back counter notices on materials, because you should exercise your right, especially if it's original. The platform is designed to be wide-scale distribution, and you really can't let people recklessly abuse the notice system in order to further their gains. And a lot of times they're just not looking at it. As you saw from the Lens video, there's nothing about that is really taking away from the music industry. So that's all I have. Any more questions? Yeah.
$25,000
Yeah.
penalty.
Yeah, that's a statutory penalty. There's other forms of damages. That's just a statutory damage. That's why people that's for people that have registered, and it's sort of the benefit of copyright law, and that's per infringement claim. So you can get per material that you've infringed.
So per claim, like that video?
Yeah, that was one, that's one, yeah.
Is that one claim? Or
Yeah.
One claim per view, or is that?
Well, that, once you get to that, yeah. There's a lot of hypotheticals you can run with it. Really, the purpose of that is just to give you an understanding of how serious it is. It doesn't incur necessarily only damage to the copyright holder. There's statutory set per occurrence fines that they're essentially fines for it. But that is just a way to express how it can get out of control really fast, and the cost of getting yourself a good copyright policy and notice scheme is really pennies relative to what trouble you can find yourself in. And the likelihood you're actually going to get sued for copyright infringement, if you're not, is probably very low. But when you do, this protection will allow you a way to respond to it rather than just being an infringer. So, all right. Oh, go ahead.
I was going to, how is BitTorrent substantially different from Napster in the legal sense? Because
Well,
that's still alive and well.
Yeah, they're barely.
We have an infringer here.
Yeah. So BitTorrent is what's the purpose of BitTorrent? Is a file transfer system. They're not necessarily a particular type of file transfer system, which is Napster made the argument. Napster just was completely all music. It advertised, it published stuff that says, this is how you can replace all of your CDs and you don't have to go buy they really went down the marketing scheme of it. And they actually, if you watch documentaries on it and interviews with the guys, they were hoping, and I think a lot of people in the music industry thought they would be further along in the digitalization of music if they negotiated some sort of settlement where they said, okay, pay licensing fees like they do today for each one that passes through. Napster would have said, sure. But the music industry it came up so fast, they didn't know how to react to it. They just stood their ground and said, we are not negotiating. Basically, we don't negotiate with terrorists. So, and that's their position. I think the music industry itself was harmed from it. That's a personal opinion. And then also that we're now slowly getting to where they could have been 5 years ago if they just would have started from point one and said, okay, it's clear that the people want something different. Let's figure out a way that I can make money and you can make money and we'll all go down the road. So
BitTorrent never got in the position of being that yellow pages of infringement there. Right?
yeah,
I mean,
yeah.
it's a strict, they did this part, the P2P part, which they still do.
Yeah.
But they never got into this idea. It's like, we will host the directory of who you need to contact if you want to.
Right,
And that's
exactly.
what they were really
Yeah,
focused on.
and one of the things that Napster did with this directory is they showed you like the popular, like what people were stealing most. And then you found out pretty quickly, the next big hit, or it was really an interesting cultural thing, but in sort of changing the way we experience music. But they never, and there's a lot of other stories there that I could talk to you guys about related to where we have a theory that at the end of this, all these music services will sort of conglomerate into one or two of the major players because they're just under this constant attack. And the idea that there's some other way to get music other than paying for it, it's really sort of just a trap to get you used to using it. They can't go on that way, and services have tried all sorts of different mechanisms like this, and they get far and far down the road, and then they get shut down. They get sued and shut down.
I was in Los Angeles working in this industry when this happened, and I saw the music industry just evaporate in the less than 3 or 4 years, to the point where I can't remember the last time the record that has been since like 1998. There hasn't really been a diamond. You know what diamond is? It's over 10 million sales.
Mm-hmm.
So it's just, people just, why would you buy it if you can get it for free, right?
Right, absolutely. And the free thing now is to get, all of us are probably tech savvy enough and are into digital music already, but there is a huge, enormous amount of people that aren't yet. And they're trying to get those people hooked. Once they're hooked, then they can start charging. So that's where this freemium thing comes into place. There's still, and the only way you can make money selling music, because your profit margins are exactly the same, because your license fee per song is exactly the same per play, is to increase numbers, your amount of your user base. So that's why advertising and Spotify and Pandora, the only thing that really matters for their increased revenue streams ultimately is bigger user base, so they can increase that number as it gets the same, but if you have huge user base. So, but all right, well, that's where we'll leave it. Now I can answer questions afterwards, and we'll call that a wrap.